Hi, this is the business guy with Asset Protection Planners. Today we're talking about 9 privacy techniques to keep a low profile and protect your assets from lawsuits. With 4.4% of the world's population, 80% of the world's lawyers, and 96% of the world's lawsuits in the U.S., it is now more important than ever to maintain privacy. Thus, it is a wise financial strategy to keep a low profile as to not become a lawsuit target. Drive a nice car, live in a nice house, post your vacation photos on Facebook, you've just poured blood in the water for the shark-like lawyers to attack and make what's yours theirs. So the importance of taking the necessary steps toward protecting your assets and maintaining a low profile is crucial. That is, if you wish to avoid a bloody battle with lawsuits and creditors. The fact is especially true today since there are more and more lawsuits plaintiffs file every decade and increasing theories of legal liability. The time is now to understand both asset protection and privacy techniques. Face it, you could be the next victim of a lawyer who wants an easy meal. So you should prepare yourself now. Protect yourself against potential losses that you could incur if you skip out on constructing your asset protection plan. So you can learn how to protect your assets and employ privacy techniques right now. So there's no reason you should fear losing your assets in a potential lawsuit. That is, if you prepare ahead of time. This way you know that your lifestyle and hard-earned wealth remain protected even when the predators start to circle you. That way, you can sleep easily even if you do get caught in a row of legal teeth. And you'll make my teeth smile when you click the like button below so YouTube promotes this video. Thank you so much. And if you're new here or just need a friend, please click the subscribe button below so that when more videos come out like this, you'll be up to date right away. What follows now is a list of 9 asset protection and privacy techniques. They can help you to keep a low profile and keep your assets safe, not only for yourself and your immediate family, but future generations. Many people use a combination of techniques to develop a secure asset protection privacy plan. Asset protection and privacy tool number 1, a New Mexico LLC. With a New Mexico LLC, you never have to file a list of managers. Who owns and manages the LLC is private. There's nothing in the public records disclosing ownership or management. Nobody can find out who owns it unless you tell them or a court forces your hand. Unlike Nevada, which as of this writing charges well over $500 for the initial and annual business license fee on top of the setup fee and $200 more for LLCs, the annual fee for a New Mexico company is $0. That's right, nothing. The only typical annual cost is the registered agent for service of process for the LLC. This is typically under a few $100, so you get substantial anonymity with very little maintenance. Number 2, a Nevis LLC. Whereas the New Mexico LLC does not have to file a list of managers, it can be subpoenaed. Moreover, in seconds, anybody can look on the internet to see the company exists. The Nevis LLC cannot even be found online. Nevis is part of a former British colony in the Caribbean island southeast of Florida. Our firm has set up thousands of companies there, so you can call us for more information. The public record is not viewable on the internet, so nobody would easily know that the company was even created. Plus, you're dealing with offshore bank accounts in the name of the LLC. Therefore, you are working with a bank that some attorney down the street cannot simply force to cough up information. So whereas New Mexico LLCs are good, the Nevis LLC is much better for use as a privacy tool. Here are some of the benefits of the Nevis LLC. First of all, the manager is not publicly recorded, but can have 100% control, and that can be you. Secondly, the manager can control even without ownership. Creditors must post a bond before filing legal documents in Nevis against a member's ownership interest in the LLC. In 2018, the $100,000 limit on the bond amount was removed, and now the Nevis courts can impose a bond of any amount. Courts will dismiss the case if the assets have been in the LLC for over 2 years. An LLC or corporation in just about any country can become a Nevis LLC. Proof beyond a reasonable doubt is required for a plaintiff to show that a transfer was made with the intent to hinder or delay creditors. Unlike most states in the U.S., multi-member LLCs and single-member LLCs get asset protection benefits. Charging orders against an LLC member's interests fall off in 5 years. An unlimited number of members are available. Any person or company can own it. There's not any tax in Nevis for income produced outside of Nevis, but U.S. people are taxed on worldwide income. Members can reside in any country. It can be merged with foreign or domestic companies. A one-owner LLC is available. Can be established within 24 hours and usually delivers within 7 days. And finally, low initial and annual fees. Asset protection and privacy tool number 3, a Wyoming corporation. Now, when you name a corporation, most states and countries require a corporate designator at the end of the name. Corporate designators include words such as corporation, incorporated, limited, and their abbreviations Corp, Inc., and Ltd. In Wyoming, a corporate designator is not required. And what this means is, if your name is Pat Gunderson, you can simply name the corporation Pat Gunderson without the Inc. or Corp as an ending. Suppose you have a judgment against you and receive a check payable to yourself. Do you think it could be beneficial to deposit it into your corporate account? Since your corporation has its own tax ID number, there is no easily traced direct tie back to you. You can have a trusted family member or friend be the signatory on the corporate account, with an emphasis on the word trusted, mind you. You can perhaps have your hands on the debit card. So now you have an avenue to cash checks payable to you without making it easy for somebody to just come in and scoop your account dry without prior notice. Can this tactic survive an all-out legal assault? Well, it depends. First, your opponent would need to know it exists. It would be more likely to survive a legal onslaught with the additional tools listed below. Whether or not it can withstand a strong legal storm, it gives you an opportunity to conveniently cash checks made payable to you. Our company has witnessed a multitude of people use this technique so successfully, they fly under the radar for many years. Privacy tool number 4, Wyoming LLC plus privacy tools. First, you set up a Wyoming LLC. Next, to work properly, your Wyoming LLC needs 3 additional services. Number 1, a Wyoming virtual office program. Now, this program offers an address and telephone number for the company. So if anybody comes sniffing around to see if the company is associated with you, there will not be an obvious trail. Number 2, nominee officer and director service. Since officers and directors, and in this case managers, are listed in the public records, having a nominee means in name only. Serve as officers and directors of your company. You can maintain control, having the membership voting rights in your hands or the hands of a trusted family member or associate. Number 3, nominee member. By having a nominee member, if somebody asks, do you own the company, you can honestly say that you do not. Depending on your legal circumstances, you may want to have the company owned by your spouse, kids, parents, or trusted associate. A nominee membership agreement can give you the say-so over company activities, but keeps your ownership at arm's length. Asset protection and privacy tool number 5, a land trust. A land trust is a trust used for holding title to real estate. When you establish a land trust, you can own your property in the name of a trust/trustee instead of your own name personally. This keeps your name out of the public records, and what shows up publicly is the name of the trust and the trustee. The trustee can be a trusted friend or relative, a trust company, or better yet, a Wyoming LLC that you own privately that has nominee managers and a Wyoming virtual office address. We provide all those services, so give us a call. That way, if somebody does a public record search and all of your real estate holdings are in separate land trusts, your name does not appear in the search. This allows you to keep your real estate ownership private and away from prying eyes. You can establish a land trust for your personal residence, and additional land trusts for each piece of income property, a second home, or other types of real property. The Garn-St. Germain Depository Institutions Act of 1982 prevents a bank from calling the loan due when you transfer property into a land trust, as long as you remain a beneficiary and the property consists of 1 to 4 dwelling units. Now, land trusts are currently in use in all 50 states. Now, some state statutes don't address land trusts and others do. The state code does not need to specifically address this type of trust in order for it to be legal. Not every facet of life has been codified into law. For example, the state or federal code does not address the manner in which you style your hair in order for a particular hairstyle to become legal. It does not dictate how many books you may own or the color of your shoes. So in such cases, common law dictates. Common law has to do with which activities have been generally accepted over the centuries. It is the unwritten law, especially that originating from England based on custom or based on court decision, rather than from written statutory law. Common law certainly does permit the use of trusts to own real estate. Land trusts are not asset protection vehicles. They're privacy vehicles. It is considered best practice for each land trust that owns income property to have a separate LLC as its beneficiary. This both cloaks the ownership with a land trust and provides an asset protection and lawsuit protection tool, which is the LLC, to help protect the affiliated human beings from litigation. For home ownership tax benefit purposes, it is generally recommended that natural persons remain as the beneficiaries of land trusts that own personal residences. This can help maintain the interest deduction, property tax adjustments, and the sizable tax-free profits upon sale. Asset protection privacy tool number 6, family LLCs and limited partnerships. Both family limited liability companies and family limited partnerships offer a good deal of asset protection privacy from creditors and lawsuits. With either one of these entities, you can put your assets into the actual company or partnership. You can have nominee managers for your LLC so your name does not appear in the public records. If you do use an LP, since the general partner is vulnerable to lawsuits against the partnership, you can place an LLC as the general partner of the LP as a liability shield. Picture yourself putting your assets securely into the company or partnership. First, it can protect your privacy. Then, because of the asset protection provisions inherent in each of these entities, it shields your assets. Thus, an LLC or LP can shield your assets from a creditor trying to seize them when you happen to find yourself in a lawsuit. Number 7, domestic asset protection trusts. Trusts allow you to hold assets privately. In some states, such as California, you need to be aware that how you structure an irrevocable asset protection trust for asset protection and privacy will determine whether you'll receive either. For instance, in California and many other states, forming your own irrevocable trust and listing yourself as the beneficiary eliminates its ability to protect assets from creditors. To sum it up, if you are the beneficiary of your irrevocable trust in certain states, you are giving away your asset protection and privacy because this type of trust cannot legally protect you from creditors. It is considered a self-settled trust. Now, there are states that allow self-settled trusts to provide asset protection. These states do let individuals form irrevocable asset protection trusts that name themselves as beneficiaries. They allow people to form these trusts in this manner and still retain protection from creditors. In states that allow self-settled asset protection trusts, a trust like this can help you shield yourself from creditors and lawsuits. Thus, it is very important for you to understand that where the trust is domiciled determines whether you can use it for privacy and asset protection planning. There is a lot of case law wherein if the beneficiary of the trust does not actually reside in the jurisdiction that allows self-settled asset protection trusts, the trusts have been penetrated repeatedly. For example, a California, Texas, Florida, or New York resident who sets up a Nevada trust is not well protected when you study the actual case law. And that is why the Asset Protection Trust we'll talk about next has the strongest asset protection history. Number 8, Offshore Asset Protection Trust. Offshore asset protection trusts are a huge step up and take asset protection and privacy to a whole new level. Asset Protection Trust in the Cook Islands, Nevis, and Belize allow self-settled trusts that provide powerful asset protection. Whereas U.S. judges have jurisdiction over U.S. trusts, having an offshore trust, offshore trustee, in which our case is our offshore law firm, as well as an account offshore, takes much of the decision-making out of the hands of the local courts. In fact, in the 30 years since I've personally been in the asset protection business, I have never seen a trust settler or beneficiary lose funds from an offshore trust that we have established. So among all the tools available, the Offshore Asset Protection Trust has shown to be the most powerful asset protection vehicle for liquid assets. Your offshore trust will own 100% of an offshore LLC. The offshore LLC holds a bank and/or brokerage account. You are the signatory on the account until it's time for our trustee/law firm to step in and protect you from the judge ordering you to bring the money back. When you put your assets into a Cook Islands trust, they are protected immediately. On top of that, there is a 1 to 2 year statute of limitations for fraudulent transfer in the Cook Islands. So when you establish a Cook Islands trust and place your assets into it, if your opponent beats the clock and files a lawsuit in the Cook Islands before the deadline, it is unlikely your opponent could reach your assets. However, if you put your assets into the trust and they've been there for 2 years or more, it is almost impossible for your opponent to reach them, and that's because the courts refused to even hear the case after that time. Can you trust the trustee? The trustee has to go through excruciating background checks in order to obtain a license. The trustee is bonded by an insurance company. The trust company consists of multiple lawyers and is bonded by an insurance company that can make you whole in the event of misconduct. Plus, I've been in the business for over 30 years and have yet to see a settler or beneficiary treated unethically. Now keep this in mind. The only time the trustee would step in is when the courts would take the money. And that's why we put the LLC inside of the trust. Let's say you're in a sinking rowboat in the middle of the ocean and a cruise ship goes by. Are you going to tell the captain, I would climb aboard your ship, but what if it sinks? Or are you just going to climb aboard? It's the same here. You only need the trustee to step in when you feel that your financial boat is sinking. Number 9, offshore captive insurance companies. Offshore captive insurance companies offer substantial ongoing tax deductions at a very reasonable price. Not usually considered a privacy tool, it offers such tremendous benefits in other arenas, it's worth mentioning. First, let's address the captive insurance program as a powerful tool for those with an extra cash flow who want to take advantage of a huge federal tax loophole. If you want to protect that extra cash, as well as giving yourself some extra privacy and asset protection, forming your own insurance company and paying that company insurance premium payments provides you with an excellent shield from losing that excess wealth if a lawsuit attacks. It works like this. Number 1, establish your own offshore insurance company, preferably offshore where the cost is less. Number 2, have your local company pay insurance premiums. Number 3, Internal Revenue Code Section 831B allows your insurance company to earn up to $2.3 million each year in premium income tax-free. Number 4, you own your own insurance company in an offshore asset protection trust. So your company gets to deduct the premiums as an ordinary and necessary business expense. Then your insurance company, which has made a 953D election, gets to claim the premiums as tax-free up to $2.3 million per year. Your premiums can turn out to be income tax deductions. Furthermore, as mentioned, you can hold shares of your insurance company in an offshore irrevocable trust for asset protections. Now, there's a lot more to it, so make sure to get good licensed tax and legal advice. So those are some of the many privacy tools that we put into place for our clients. And if you have any questions or want to protect your assets or enhance your privacy, give our asset protection attorneys and consultants a call at 1-954-400-1050 or fill out a free consultation form at assetprotectionplanners.com. Please click like, subscribe, and text a link of this video to others. We'll see you next time. This is The Business Guy.